Hello everyone, welcome to Educate in channel. In this video, let us see the center and state relations. So we see that our constitution is in federal structure, which divides all the powers into legislative, executive, and financial. So these are the three relations with respect to center and state. So our constitution being federal, it is a federal system. So it divides all the powers into legislative, executive, and financial. So, however, there is no division of judicial power. So if we see the constitution, there is an integrated judicial system which deals with both the central laws and as well as the state laws. So with respect to judicial, there is only integrated judicial system, that is only one. So though the states and the center are supreme in their respective fields, the maximum harmony and coordination between them is essential for the effective operation of the federal system. So meaning of this is, if we see the federal system, it talks about division of powers between union and states. So we see that our constitution of India being federal, it divides all the powers between center and states. So here it is already accepting the federal system. However, but there is only integrated judiciary which deals with both central laws and the state laws. So in the federal system, there will be the mutual cooperation and coordination between the center and the states, which is really necessary for the liveliness of this federal system. So, hence, the Constitution contains elaborate provisions to regulate the various dimensions of relations between center and states. So, there are certain provisions to regulate these various dimensions of the relation between this center and states. So, in what ways we can see the center and state relationship? They are actually three, as we read in the first point, that is legislative relations, administrative relations, and financial relations. So in this video, I will be dealing about the first one, that is legislative relations. So I will try to complete this topic, that is legislative relations with respect to center and state relations. Okay, then which articles will deal about this legislative relations? So articles 245 to 255, 245 to 255, which are part 11, deals with the legislative relations between center and the states. So apart from these articles, there are certain articles which deals about the same subjects which are represented in article number 245 to article number 255. So the legislative relations between center and states are represented in 245 to 255 articles which are present in part 11. Then, like any other federal constitution, the Indian constitution also divides the legislative powers between the states and center with respect to both the territory and the subject of legislation. So meaning of this, see, if we see any federal constitution, it deals the powers between states, that is union and the states, as well as Indian constitution also we see that powers are divided between union and states, that is center and states. So as well as the legislative powers also divided between the center and states with respect to both the territory and the subjects of legislation. The Constitution provides for the parliamentary legislation in the state field under five extraordinary situations, as well as the center's control of the state legislation in certain cases. So, meaning, so if you see the like any federal constitution, the Indian constitution also divides the powers between the center and the states with respect to what? With respect to the territory, with respect to the territory and the subjects of the legislation that is making of laws. So, based on these, the territory and the making of the laws, so the powers have been divided. What are those powers? Those are legislative powers which are divided between the center and the states. And apart from this, the Constitution provides parliamentary legislation in the state field under five extraordinary situations. So, meaning of this is, so the parliamentary legislation can be observed in particular state field, that is in all states, under five extraordinary situations. There are five situations where the parliamentary legislation will take place instead of the state's legislation, as well as the center's control over the state legislation in certain cases. So center's control will be there over the state legislation in certain cases, and in five extraordinary situations parliamentary legislation is observed in the state field. So thus we can see four aspects in the center and state relations. Those are territorial extent of the center and state legislation. So meaning is, up to what extent the center and state legislation. So if any laws are there, up to what extent it applicable to the central, and up to what extent it is applicable to the states. So that is in dealing with the first one. So distribution of legislative subjects. So we have three lists over here, that is union list, state list and concurrent list, which are in 7th schedule of the Constitution. So this we will be seeing the distribution of the legislative subjects. Then parliamentary legislation in the state field. So we have seen already five extraordinary situations. So in five situations this will happen. Then center's control over state legislation, that also we will be seeing in what cases and or in what ways center will control over the state legislation. So let us go with first one, that is territorial extent of center and state relation. That is the first one with respect to the legislative relations of center and state. So here we see territorial extent of central and state legislation. So the Constitution defines the territorial limits of the legislative powers vested in the center and the states in the following way. So the legislative powers vested in central and states, the legislative powers are having the limits up to certain territorial limits. So in which the powers are vested with center and as well as the state. So the first one is, the parliament can make laws for the whole or any part of the territory of India. So it is clear that parliament can make laws for the whole, for India or any part of the territory of India. Here the territory means it includes the states, the union territories what we have, and any other area for the time being included in the territory of the India. So at this particular cases, that is, the parliament can make laws for the whole, that is total India or any part of the territory of India. Here territory comes the states, the union territories and any other area for the time being included in the territory of India. For all the territories, parliament can make laws. That is the first point for the territorial extent of central and state legislation. Then, a state legislature can make laws for whole. They can make the laws for their state or any part of the state. So, any part of the state, if the state will be there, for this particular part, they can make the laws, or else for total territory, they can make the laws. The laws made by a state legislature are not applicable outside the state except when there is a sufficient nexus between the state and the object. So, the state legislature, whatever making laws, are not applicable outside the state. So, this is clearly stated in the second point. Then, the parliament alone can make extraterritorial legislation. Thus, the laws of the parliament are also applicable to the Indian citizens and their property in any part of the world. So, parliament is also having a provision that can make extraterritorial legislation. So, it is not our territory, but where Indian citizens and their property in any part of the world, that laws which are made by the parliament are applicable to those territory where the Indian citizens and their property is in any part of the world. However, the constitution places certain restrictions on the plenary territorial jurisdiction of the parliament, meaning they are not applicable in the particular following areas. So which areas will we see? That one. Then the president can make regulations for the peace, for the purpose of the peace and for progress and good government of the 4 union territories. The president can make some regulations. So what are those union territories? Those are the Andaman and Nicobar Islands, Lakshadweep, Dadra and Nagar Haveli, and Daman and Diu. For these particular 4 union territories, the president can make regulations for what purpose? For peace, progress, and good government. For these all union territories, those are 4. For them, the president can make some regulation. So the regulation which was made has the same force and effect as an act of parliament. So meaning if parliament makes any act, that is law, it will be applicable in that particular territory. In the same way, the president can make some regulations for the peace and good governance and the progress of the governments of these 4 union territories, which will be acted as an same and came into force with same effect as an act which is made by the parliament. And it may also repeal, that it can be removed or it can be amended by the parliament in relation to these union territories. That means, so first president will make some regulations. So for what? For peace purpose and for progress and good government of these 4 union territories. And it will came into force as the act which will be coming into force after parliament enacted it. So it may also repeal or amend any act of parliament in relation to these union territories. That means whatever the acts which are related to these four union territories, they may be removed or it can amend. That regulations can amend for these four union territories. So this is one. Next, the governor is empowered to direct that an act of parliament does not apply to a scheduled area in the state or apply with specified modifications and exceptions. So here we see the president can make regulations to these particular four union territories. In this point, we see that governor is empowered to direct that an act of parliament does not apply to the scheduled area. So whatever the act is made by the parliament, that is not applicable to the scheduled area in the state or apply with specified modifications and exceptions. So for that act, there will be some modifications and there will be some exceptions which for the provisions which are mentioned in that particular act. So for this, governor of the state is empowered. As well as governor of Assam may likewise direct that an act of parliament does not apply to a tribal area, that is autonomous district in the state, or apply with the specified modifications and exceptions. So here we see the governor is empowered to direct that an act of parliament does not apply to the scheduled area. So here we see that in all the states, the governor is empowered. But the governor of Assam may likewise direct that an act of parliament does not apply to a tribal area, that is autonomous district in the state, or apply with specified modifications and exceptions. So this is particular for the governor of Assam, and this in whole for the all states governors. So the president enjoys the same power with respect to tribal areas in Meghalaya, Tripura and Mizoram. Those are autonomous districts. So with respect to Assam and with respect to tribal area of Assam, governor is empowered, and with respect to Meghalaya, Tripura and Mizoram, the same power is laid in the president. So these are the provisions that the Parliament Act is not applicable to certain territorial extents. So these are the three clauses where those acts were not applied or applied with the modifications and exceptions to particular scheduled area and tribal areas. If we see with respect to the Assam and all the states with respect to scheduled area. Then we see here distribution of legislative subjects. So we have three lists. Those are union list, state list and concurrent list. So these lists are mentioned in 7th schedule of the Constitution. So what are these? So the Parliament has exclusive powers to make laws with respect to any of the matters enumerated in the union list. This list has at present 100 subjects, but originally those are 97 subjects. That means Parliament is having powers for what? To make the laws for the subjects or any matters which are in union list. So whatever the subjects or particular matters present in the union list, who will be empowered to make the laws? The Parliament is empowered to make the laws. Those list is having 100 subjects. At present it is 100, but originally those are 97 subjects. So those are defense, banking, foreign affairs, currency, atomic energy, insurance, communication, interstate trade and commerce, that is in between states and commerce, census, audit and so on. So with respect to these subjects, the Parliament is empowered to make the laws. So that is the matters which are present in the union list, the parliament is able to make the laws. So what about the state list? The state legislature has in normal circumstances exclusive powers to make laws with respect to any of the matters enumerated in the state list. So here we have some clause. What is that? In normal circumstances. So only in normal circumstances, the state legislature as parliament. So parliament can make the laws for the subjects which are in the union list, and second one is the state legislature can make the laws, and it is having the power to make the laws for the subjects or matters which were present in the state list. So it is at present 61 subjects, and originally those are 66 subjects. So what are those? Those are public order, police, public health, sanitation, agriculture, prisons, local government, fisheries, markets, theaters, gambling, and etc. So clearly we see that parliament is empowered to make the laws with respect to union list, and state legislature is empowered to make the laws with respect to state list. So what about the concurrent list? So we have total three lists in 7th schedule. Those are the union list, state list, and concurrent list. So we have seen union list, we have seen state list. So let us discuss about concurrent list. So here both parliament and state legislature can make laws with respect to any of the matters enumerated in the concurrent list. So meaning is simple. So whatever the subjects or matters in concurrent lists, those matters and subjects, the parliament also empowered, the state legislature is also empowered to make the laws. So at present these are 52, originally 47 subjects. Those are criminal law and procedure, civil procedure, marriage and divorce, population control and family planning, electricity, labor, welfare, economic and social planning, drugs, newspapers, books and printing press, and some others. So with respect to these all subjects, these comes under matters of concurrent list. So these matters which are present in the concurrent list, on this if a law shall be made, so it can be made by both parliament and state legislature. So the 42nd Amendment Act of 1976 transferred 5 subjects to concurrent list from state list. So from state lists, some subjects were transferred to concurrent list. So here state list previously, whatever the 5 are there, it comes under state legislature to make the laws on them. But through 42nd Amendment Act of 1976, 5 subjects transferred to concurrent list from state list. So what are those? Those are education, forests, weights and measures, protection of wild animals and birds, and administration of justice, constitution and organization of all courts except the Supreme Court and High Court. So on these subjects, 5 subjects, so these were transferred from state list to concurrent list through 42nd Amendment Act of 1976. So there are some residuary subjects, meaning the leftover subjects which are not enumerated in either the state list or union list or concurrent list. So those will be in residuary subjects. So the power to make the laws with respect to residuary subjects, that is matters which are not enumerated in any of the three lists, will be vested in the Parliament. These residuary powers of legislation includes the power to levy residuary taxes. So only Parliament can make the laws on the subjects which are not mentioned in either of the three lists. So if we see that in case of the national importance and the matters which require uniformity of legislation nationwide are included in the union list, and the matters of the regional and local importance and the matters which permit diversity of interest are specified in the state list, and the matters on which uniformity of legislation throughout the country is desirable but not essential are enumerated in concurrent list. So thus it permits diversity along with uniformity. Then in US, if we see, only the powers of the federal government are enumerated in the constitution, and the residuary powers are left to the states. Okay, so with respect to the US constitution, we see that powers of the federal government are enumerated in the constitution, but whatever the residuary powers are there, that are left to the states only. So same Australian constitution followed the American pattern of single enumeration of the powers. So whereas in Canada we see that there is a double enumeration, that is federal and the provincial, and the residuary powers are vested in the center. So federal, that is the powers vested in the Parliament, and provincial, the powers vested in the state legislature, and the residuary powers in Canada. If we observe, the parliamentary form is taken from the Canada only. So sorry, the parliamentary form is taken from the British, and here the federal system is taken from the Canada. So if we see the Government of India Act, that is 1935, it is provided with the threefold enumeration, that is federal, provincial, and concurrent. So the Indian Constitution taken lot of points from Government of India Act of 1935 only, but here through Government of India Act of 1935, there are total threefold enumerations, that is federal, provincial, and concurrent. So the present constitution follows the scheme of this act only, that is Government of India Act of 1935 only, but only with one difference, that is under this act the residuary powers were given neither to the federal legislature nor to the provincial legislature, but to the Governor General of India. So if we see present situation, that is union list is under, that is union, and state legislature, that is state list, that is under state legislature, and concurrent is under Parliament. However, if we see the Government of India Act of 1935, the residuary powers which are vested in Parliament right now, but during the Government of India Act of 1935, those were vested with Governor General of India. This is the only difference between then and now. So with respect to the Canadian President, the Constitution expressly secures the predomination of the union list over the state list and the concurrent list, and that of the concurrent list over the state list. Thus, in case of overlapping between the union list and the state list, the formal should prevail. Meaning, if there is a overlapping between union list and state list, former should prevail. That is, at this particular cases, whatever the laws made by the union, that will be taken into account. Whereas in case of overlapping between the union list and concurrent list, it is again the farmer which should prevail. That is union list only. The laws made by the those parliament will come into account. Then, where there is a conflict between the concurrent list and the state list, it is the farmer that should prevail. That is concurrent list. So, in case of a conflict between the central law and the state law on a subject enumerated in the concurrent list, at this particular case, central laws prevails over the state law. That is, central laws will be given importance of the concurrent list over the state law. However, there is an exception where state law has been reserved for the consideration of the president and has received his assent, then the state law prevails in that state. Meaning, one exception is there where state law has been reserved for the consideration. So they should consider the state law as for consideration of the president. If that state law went for the consideration of the president and once it got the assent of the president, then the state law prevails in that state. So in that particular state, whatever the state legislature makes the laws, that will become important. But it would still be competent for the parliament to override such a law by subsequently making a law on the same matter. So on the same matter, the parliament can also make law even though the state is having the president assents for that particular law. The parliament is having certain provision which was mentioned in our constitution. So we have seen already 2 points with respect to the legislative relations. So this is the third one, that is parliamentary legislation in the state field. So we see that there are certain provisions in the constitution where in the state field, apart from the state legislature, there will be parliamentary legislature under 5 extraordinary situations. So what are those? So those are when Rajya Sabha passes a resolution. That means if the Rajya Sabha declares that it is necessary in the national interest that parliament should make laws on a matter in the state list. So when this parliamentary legislation will be in the state field, first one is Rajya Sabha passes a resolution that the parliament should make the laws on the matter of the state list. At this particular point, if a resolution is passed by Rajya Sabha on that matter, the parliament can make laws with respect to state list. However, such a resolution must be supported by 2/3 of the members present and voting. So the resolution remains in force for 1 year. Such a resolution will remain in force for 1 year. It can be renewed any number of times, but not exceeding 1 year at a time. So whatever the resolution made by Rajya Sabha through 2/3 of the members present and voting, so that parliament can make the laws on the matters which were represented in the state list, that will remain in force for a period of 1 year. It can be renewed any number of times, but not exceeding 1 year at a time. That is the first point. So these laws ceases to have an effect on the expiration of the 6 months after resolution has ceased to be in force. This provision does not restrict the power of a state legislature to make laws on the same matter, but in case of inconsistency between a state law and a parliamentary law, the latter is to prevail. Meaning, so Rajya Sabha passes a resolution, so that will be in force for 1 year, and this can be renewed number of times, but not only 1 year at a time. This is one. And next one is, even though parliament is making the having the power to make the laws on that particular subject. The state legislature is also equally eligible to make the laws on the same matter. But if there is any inconsistency between a state law and a parliament law, the latter is to prevail. That is, parliamentary law will be given importance at that particular point. Then another situation where parliamentary legislation in the state field is during a national emergency. So, the parliament acquires the powers to legislate with respect to matters in the state list where there is a national emergency. So, the laws become inoperative on expiration of 6 months after the emergency has ceased to operate. For example, for a particular period, there is a national emergency. At this particular point, the laws will be made by, or the parliament acquires the power to legislate, that is, making laws with respect to the matters in the state list. So, after this period of emergency is completed, then 6 months, whatever the laws made by the parliament will be in effective only. After 6 months only, the laws will be expired. So, here also the power of a state legislature to make the laws on the same matter is not restricted. So, state legislature can also make the laws on the same matter where the parliament has made the act. But in case of, again, inconsistency, a state law and a parliamentary law, the latter is to prevail. At this point also, parliamentary law will be given importance even though a state law is made if there is any inconsistency on that matter with respect to state law and a parliamentary law. And next one is when states make a request. That means the states will request the parliament to make the laws on certain subjects. So at that particular place also, the parliament legislation will be in the state field. So what are those? When the legislatures of two or more states pass resolutions requesting the parliament to enact laws on a matter in the state list, then parliament can make laws for regulating that matter. So meaning is when two or more states, that is two or more states, will pass a resolution requesting the parliament. They will request the parliament to make laws on certain matters to regulate it. So on this particular resolutions, the parliament can make laws. So whatever the laws made on those matters by which the states has been requested, so only in those states the law is applicable. However, if any of the state may adopt it afterwards by passing a resolution to that effect in its legislature, that means two or three states first they will approach to the parliament to make the laws on certain matter to regulate it. So once the resolution has passed and the parliament has adopted some laws, so after this, if any of the state want to adopt the same laws in their state legislature, they have to pass a resolution and that resolution has to be passed and then only they can use that law. So such a law can be amended or repealed only by the parliament and not by the legislature of concerned states. So any amendment or again removal of the law can be only vested in the parliament and not by the state legislatures. The effect of passing a resolution under the above provision is that the parliament becomes entitled to the legislate with respect to a matter for which it has no power to make a law. So meaning the effect of passing a resolution, so we see that under above provision, the state legislature will pass the resolution to empower the parliament to make the laws on the matters which are represented in the state list. So that means the parliament is not having the power to make the laws with respect to states matter until and unless a resolution is passed by the states itself. And on the other hand, the state legislature ceases to have the power to make a law with respect to that matter. So in the above two cases, we see that the parliament will make laws and the state also having authority to make the laws on that particular matter. If any inconsistency is observed, parliamentary law will be taken importance. But in this particular point, when states make a request at this particular point, once the parliament makes some laws, they have to follow that, and states cannot amend or repeal that particular law. And on the other hand, the state's legislature ceases to have the power. Again, they cannot make any laws on this particular subject. The resolution operates a fiction or surrender of the power of the state legislature with respect to that matter, and it is placed entirely in the hands of the parliament. So we have already seen this. So what are some of the examples which are passed under above provision? So those are Price Competition Act of 1955, Wildlife Protection Act 1972, Water, that is Prevention and Control of Pollution Act 1974, Urban Land Sealing and Regulation Act 1976, and Transplantation of Human Organs Act, that is 1994. These are acts which are made by the resolution made by the states to parliament. So they have requested or they have given the power to parliament to enact laws on that particular matter to regulate. So these are the particular laws which are made by through that provision. So, and to implement international agreements, the parliament can make laws on any matter in the state list for implementing the international treaties, agreements, or conventions. This provisions enables the central government to fulfill its international obligations and commitments. So meaning of this, here parliament can make laws on any matter which is represented in the state list for implementing what? For implementing the international treaties, that is treaties between the nations, and agreements or conventions. This provisions enables the central government to fulfill its international obligations and commitments. At this particular point also, the parliament can make laws. So those are some examples are United Nations, that is Privileges and Immunities Act 1947, Geneva Convention Act 1960, Anti-Hijacking Act 1982, and legislations relating to the environment and trips. So these particular acts, these are made through implementation international agreements. So to implement international agreement, at this particular point, the parliament is empowered to make the laws any matter with respect to state list to achieve this particular one, that is international agreements. And then during president's rule also, the parliament legislation will be in the state field. So if the president's rule is imposed in a state, the parliament becomes empowered to make laws with respect to any matter in the state list in relation to that state. A law made by the parliament continues to be operative even after the president's rule. This means that period for which such a law remains in force is not coterminous with the duration of the president's rule. But such a law can be repealed or altered or re-enacted by the state legislature. So meaning is simple. So if the president's rule is imposed on the on states, so whatever the matter which is present in the state list, on that particular state list, the parliament will make some laws. If that has done, so after the president's rules also, the law will be in force only. So if the president rule is that is terminated, that is ended, so but the law will be in force only. At this particular point, the state legislature can make the laws on that particular subject, and apart from that, that law can be amended or repealed or re-enacted by the state legislature. This provision is given by the constitution. So these are with respect to the parliamentary legislation in the state field. So this is the fourth relation, that is particular center's control over state legislation comes under the legislative relations with respect to center and state relations. So what are they? The governor can reserve certain types of bills passed by the state legislature for the consideration of the president. The president enjoys absolute veto over them. Meaning, so there will be center's control over the state legislation. So the governor is head of the state. So the governor can reserve certain types of bills passed by the state legislature. So a bill is introduced in the state legislature and it is passed by the state legislature, and that type of the bills can be reserved by the governor, and for what? For consideration of the president. At this particular point, the president enjoys absolute veto. For the first time, he will send for the reconsideration, and for the second time also, he can send the reconsideration by not giving his assent, that is absolute veto. So this is center's control over the state legislation. And then bills on certain matters enumerated in the state list can be introduced in the state legislature only with the previous sanction of the president. See, we see that center's control over the state legislation. That means center will control the state legislation. Even though the bill was passed, it was passed by the state legislature, it can be reserved by the governor. The governor is the head of the state and he is under the control of the center only. So at this particular point, if we reserve the bill, even though it is passed by the state legislature, at that particular point, the president enjoys his absolute veto. We can send for the reconsideration that twice also. So at this particular point, the second one is bills on certain matters enumerated in the state list. That means whatever the matters with respect to state list, once bills was introduced in the state legislature, that can be done only with the previous sanction of the president. For what? For example, imposing restrictions on the freedom of trade and commerce, that is with respect to business. So with respect to trading, so these type of bills required the sanction of the president. So we see that central's control over the state. That is, third one is the president can direct the states to reserve money bills and other financial bills passed by the state legislature for his consideration during a financial emergency. So that means at particular financial emergency, the bills will be introduced by the state legislature. At this particular point, the bills, whatever they have introduced, that bills with respect to money bills and other financial bills will be under reserved by the president for his consideration at what? At financial emergency. If there is a financial emergency, money bills and financial bills will be under reserved by the president. So this is the third point where we see that central's control over the state legislation. So it is clear that the constitution has assigned a position of superiority to center in the legislative sphere. So we see that we federal system division of the powers between the union and states. However, by the above all points, we see that union is more powerful. That is, center is more powerful. So this is required for maintaining the harmony and coordination, that is cooperation between the states and the center for maintaining the federal structure of the Indian Constitution. So this is all about the legislative relations with respect to the center and state relations. So we see in the next video what are the executive relations between the center and state. So, and I thank you very much for watching this video. Please do comment in the comment box for improvements required, if any, and any topic of interest is there. So I will try to study on that particular topic and make a video. And apart from that, if you like this video, please do hit on the like symbol, and please share the videos so others can get benefit. And please do subscribe the channel for more videos, and please encourage my attempt. Thank you.